United States v. Arvizu, Supreme Court, 2002. Chief Justice Rehnquist delivered the opinion of the court. Respondent Ralph Arvizu was stopped by a Border Patrol agent while driving on an unpaved road in a remote area of southeastern Arizona. A search of his vehicle turned up more than 100 pounds of marijuana. The District Court for the District of Arizona denied respondent's motion to suppress, but the Court of Appeals for the Ninth Circuit reversed. In the course of its opinion, it categorized certain factors relied upon by the District Court as simply out of bounds in deciding whether there was reasonable suspicion for the stop. We hold that the Court of Appeals methodology was contrary to our prior decisions, and it reached the wrong result in this case. On an afternoon in January 1998, Agent Clinton Stoddard was working at a Border Patrol checkpoint along U.S. Highway 191, approximately 30 miles north of Douglas, Arizona. Douglas has a population of about 13,000 and is situated on the United States-Mexico border in the southeastern part of the state. Only two highways lead north from Douglas. Highway 191 leads north to Interstate 10, which passes through Tucson and Phoenix. State Highway 80 heads northeast through less populated areas toward New Mexico, skirting south and east of the portion of the Colorado National Forest that lies approximately 20 miles northeast of Douglas. The checkpoint is located at the intersection of 191 and Rucker Canyon Road, an unpaved east-west road that connects 191 and the Colorado National Forest. When the checkpoint is operational, Border Patrol agents stop the traffic on 191 as part of a coordinated effort to stem the flow of illegal immigration and smuggling across the international border. Agents use roving patrols to apprehend smugglers trying to circumvent the checkpoint by taking the back roads, including those roads through the sparsely populated area between Douglas and the National Forest. Magnetic sensors, or intrusion devices, facilitate agents' efforts in patrolling these areas. Directionally sensitive, the sensors signal the passage of traffic that would be consistent with smuggling activities. Around 2:15 p.m., Stoddard received a report via Douglas radio that a Leslie Canyon Road sensor had been triggered. This was significant to Stoddard for two reasons. First, it suggested to him that a vehicle might be trying to circumvent the checkpoint. Second, the timing coincided with the point when agents begin heading back to the checkpoint for a shift change, which leaves the area unpatrolled. Stoddard knew that alien smugglers did extensive scouting and seemed to be most active when agents were en route back to the checkpoint. Another Border Patrol agent told Stoddard that the same sensor had gone off several weeks before and that he had apprehended a minivan using the same route and witnessed the occupants throwing bundles of marijuana out the door. Stoddard drove eastbound on Rucker Canyon Road to investigate. As he did so, he received another radio report of sensor activity. It indicated that the vehicle that had triggered the first sensor was heading westbound on Rucker Canyon Road. He saw the dust trail of an approaching vehicle about half a mile away. Stoddard had not seen any other vehicles and, based on the timing, believed that this was the one that had tripped the sensors. He pulled off to the side of the road at a slight slant so he could get a good look at the oncoming vehicle as it passed by. It was a minivan, a type of automobile that Stoddard knew smugglers used. As it approached, it slowed dramatically, from about 50 to 55 to 25 to 30 miles per hour. He saw 5 occupants inside. An adult man was driving and an adult woman sat in the front passenger seat, and 3 children were in the back. The driver appeared stiff and his posture very rigid. He did not look at Stoddard and seemed to be trying to pretend that Stoddard was not there. Stoddard thought this suspicious because, in his experience on patrol, most persons look over and see what is going on, and in that area, most drivers give Border Patrol agents a friendly wave. Stoddard noticed that the knees of the 2 children sitting in the back were unusually high, as if their feet were propped up on some cargo on the floor. At that point, Stoddard decided to get a closer look, so he began to follow the vehicle as it continued westbound on Rucker Canyon Road toward Coy-Kendall Cutoff Road. Shortly thereafter, all of the children, though still facing forward, put their hands up at the same time and began to wave at Stoddard in an abnormal pattern. It looked to Stoddard as if the children were being instructed. Their odd waving continued on and off for about 4 to 5 minutes. Several hundred feet before the Coy-Kendall cutoff road intersection, the driver signaled that he would turn. At one point, the driver turned the signal off, but just as he approached the intersection, he put it back on and abruptly turned north onto Coy-Kendall. The turn was significant to Stoddard because it was made at the last place that would have allowed the minivan to avoid the checkpoint. Also, Coy-Kendall, though passable by sedan or van, is rougher than either Rucker Canyon or Leslie Canyon roads, and the normal traffic is four-wheel drive vehicles. Stoddard did not recognize the minivan as part of the local traffic agent's encounter on patrol and did not think it likely that the minivan was going to or coming from a picnic outing. He was not aware of any picnic grounds on Turkey Creek, which could be reached by following Coy-Kendall cutoff all the way up. Stoddard radioed for a registration check and learned that the minivan was registered to an address in Douglas that was 4 blocks north of the border in an area notorious for alien and narcotics smuggling. After receiving the information, Stoddard decided to make the vehicle stop. He approached the driver and learned that his name was Ralph Arvizu. Stoddard asked if Respondent would mind if he looked inside and searched the vehicle. Respondent agreed, and Stoddard discovered marijuana in a black duffel bag under the feet of the 2 children in the back seat. Another bag containing marijuana was behind the rear seat. In all, the van contained 128.85 pounds of marijuana, worth an estimated $99,080. Respondent was charged with possession with intent to distribute marijuana. He moved to suppress the marijuana, arguing, among other things, that Stoddard did not have reasonable suspicion to stop the vehicle as required by the Fourth Amendment. The Fourth Amendment prohibits unreasonable searches and seizures by the government, and its protections extend to brief investigatory stops of persons or vehicles that fall short of traditional arrest. Because the balance between the public interest and the individual's right to personal security tilts in favor of a standard less than probable cause in such cases, the Fourth Amendment is satisfied if the officer's action is supported by reasonable suspicion to believe that criminal activity may be afoot. When discussing how reviewing courts should make reasonable suspicion determinations, we have said repeatedly that they must look at the totality of the circumstances of each case to see whether the detaining officer has a particularized and objective basis for suspecting legal wrongdoing. This process allows officers to draw on their own experience and specialized training to make inferences from and deductions about the cumulative information available to them that might well elude an untrained person. Although an officer's reliance on a mere hunch is insufficient to justify a stop, the likelihood of criminal activity need not rise to the level required for probable cause, and it falls considerably short of satisfying a preponderance of the evidence standard. Our cases have recognized that the concept of reasonable suspicion is somewhat abstract, but we have deliberately avoided reducing it to a neat set of legal rules. We think that the approach taken by the Court of Appeals here departs sharply from the teachings of these cases. The Court's evaluation and rejection of 7 of the listed factors in isolation from each other does not take into account the totality of the circumstances, as our cases have understood that phrase. The Court appeared to believe that each observation by Stoddard that was by itself readily susceptible to an innocent explanation was entitled to no weight. Terry, however, precludes this sort of divide-and-conquer analysis. The officer and Terry observed the petitioner and his companions repeatedly walk back and forth, look into a store window. The officer and Terry observed the petitioner and his companions repeatedly walk back and forth, look into a store window, and confer with one another. Although each of the series of acts was perhaps innocent in itself, we held that, taken together, they warranted further investigation. Having considered the totality of the circumstances and given due weight to the factual inferences drawn by the law enforcement officer and district court judge, we hold that Stoddard had reasonable suspicion to believe that Respondent was engaged in illegal activity. It was reasonable for Stoddard to infer from his observation, his registration check, and his experience as a Border Patrol agent that respondents had set out from Douglas along a little-traveled route used by smugglers to avoid the 191 checkpoint. Stoddard's knowledge further supported a common-sense inference that respondent intended to pass through the area at a time when officers would be leaving their backroads patrols to change shifts. The likelihood that respondent and his family were on a picnic outing was diminished by the fact that the minivan had turned away from the known recreational areas accessible to the east on Rucker Canyon Road. Corroborating this inference was the fact that recreational areas farther to the north would have been easier to reach by taking 191 as opposed to the 40 to 50 mile trip on unpaved and primitive roads. The children's elevated knees suggested the existence of concealed cargo in the passenger compartment. Finally, for the reasons we have given, Stoddard's assessment of respondents' reactions upon seeing him and the children's mechanical-like waving, which continued for a full 4 to 5 minutes, were entitled to some weight. Respondent argues that we must rule in his favor because the facts suggested a family in a minivan on a holiday outing. A determination that reasonable suspicion exists, however, need not rule out the possibility of innocent conduct. Undoubtedly, each of these factors alone is susceptible of innocent explanation, but some factors are more probative than others. Taken together, we believe they sufficed to form a particularized and objective basis for Stoddard's stopping the vehicle, making the stop reasonable within the meaning of the Fourth Amendment.